We are here in cause number 323-11358-20 in the matter of Emma Gonzalez. It is Monday, May 11th. Are you Emma Gonzalez? All right, Ms. Gonzalez, I'm gonna need you to speak up for me. I need you to talk as loudly as I'm talking now because this hearing is being recorded. It's also being broadcast on YouTube. I will remind anybody who is watching the feed on YouTube that recording this hearing or rebroadcasting this hearing in any shape, form, or fashion is expressly prohibited. Violation of the court's order in this respect is punishable by civil and/or criminal contempt. So, Ms. Gonzalez, what is your date of birth? And that makes you how old? All right.
Your Honor.
Yes, ma'am.
I'm sorry, I can't hear her from where I'm at.
Okay. Yes, that's fine. That's fine. The only problem is her microphone is turned off.
Yeah, I guess she'll have to speak really loudly to pick up on yours. I'm sorry, I just can't hear her. And Your Honor, I'm sorry, at this time, I believe that I have to object to the proceeding as it does not comply with the Supreme Court order, that there should be no one in the courtroom and that all these proceedings should be held by Zoom.
Right. The proceedings are being held by Zoom. And I will ask the respondent and her attorney. All right, I will ask the respondent. Are you appearing in the courtroom of your own choosing?
Yes, sir.
Okay. Mr. Adler, is it your decision to appear in the courtroom personally today?
Yes, Your Honor.
I will also note the respondent's father is personally in the courtroom, that before these proceedings began, he and I discussed the availability of another courtroom for him to use for his own personal use, and a computer is available in there for him to appear by Zoom hearing, and he decided that he wanted to be in the courtroom, same courtroom with his daughter. I'll also note that the probation officer is here in the courtroom. Ms. Guerrero, is it your decision to be in the courtroom today, or do you wish to go back to your office and appear by Zoom?
Yes, Judge, I'm in the courtroom. I'll
And
stay in the courtroom. Yes.
Is that your choosing?
Yes.
All right. We have one more probation officer. And if you want, you're welcome to go back and leave today, or you may stay and remain. What is your choice?
I'll choose to stay, Your Honor.
All right. So, Ms. Smith, what is the state's objection?
Your Honor, the state just objects.
Hold on.
Let me shut my door. I'm sorry.
Ms. Smith, what is the state's objection?
Your Honor, the state objects that everyone has to essentially be in their own room on their own Zoom hearing per the Supreme Court order It's this office's understanding that if any party or witness is in the courtroom, it does not comply with the Supreme Court order, and therefore that's what we're objecting to.
All right. The court does not share your interpretation of the Texas Supreme Court's order of last week, and so your objection will be overruled.
Thank you, Your
What
Honor.
else? What else, Ms. Smith?
That's it, Your Honor.
Okay. All right. Mr. Adler, I have before me a document titled State's Disclosure of Documents, Items, and Information Provided to the Respondent. Are you satisfied with the discovery provided by the state in this case?
Yes, Judge.
Ms. Gonzalez, you have the absolute right to have a jury trial in your case. And that would be where 6 people from the community would be selected and they would decide whether or not you actually did what the state has accused you of doing. But if things proceed like I believe they're going to proceed, that won't happen. As part of a jury trial, you could force the prosecutor to call in all the witnesses who might testify against you in the state. You would get to look them in the eyes, and then your attorney would get to ask them questions to make sure they're telling the truth. And at the end of that, the jury, not the judge, but the jury of 6 people would determine whether or not you actually did what the state has accused you of doing. But if you wish to proceed today, we would proceed without a jury. And you would have everything heard by me. Do you wish to have a jury trial or do you wish me to decide everything?
You to decide everything.
Okay. Now, you also have the right to have Judge Kim hear your case rather than me. But if you'd like to proceed today, you can have it heard by me. Which would you
Estaba llamando porque me mandaron una alerta de anuncio tarde como de 15 minutos. ¿Usted sabe si Pedro
Mr.
sabe?
Adler, do you also join Ms. Gonzalez in waiving her right to a hearing before the judge?
Yes, Your Honor.
Okay, so no cree que
Also
él
join
se
her
pueda.
in waiving her right to a jury trial.
Yes, sir.
Okay. Now, Ms. Gonzalez, I will
Okay, okay. Solo van a chequear
stipulation
que a lo
of
mejor
evidence,
solo es,
confession, and
a lo mejor es
disposition.
la máquina que a veces se
It's a
equivoca,
2-page
okay?
document.
So solo,
Is that your signature near the top of that second page?
Yes, sir.
All right. Did you have a chance to go over this document?
okay. So recuérdele colocar de 2 horas todos los días y que no salga para nada. Yo sé que él está encerrado en su casa y eso es mucho, yo sé, yo entiendo.
All right, you need to speak a little bit louder.
Okay.
Okay, you're still soft-spoken. And because of all the acoustics and we're trying to record this, I need you to almost
Okay.
yell at me, okay? It'll be okay. I won't do
Okay.
that. Now, if you did ask any questions, did he answer those questions to your satisfaction?
Yes, sir.
Okay. Now you understand that the U.S. Constitution gives you another very important right, and that's the right to remain silent. Nobody can force you to talk about this case unless that's what you want to do. We call that the Fifth Amendment. However, by signing this document, you understand that you're giving up your right to remain silent. And you're actually confessing to doing what the state has accused you of doing.
Yes, sir.
Is that what you want to do?
Yes, sir.
Has anybody forced you to do that?
No, sir.
Did anybody trick you into signing that document?
No, sir.
Did the President of the United States call you last night back in detention and promise you a pardon and $1 million if you came in and signed it?
No, sir.
Are you telling me the only reason that you're giving up your right to a jury trial, that you're giving up your right to remain silent, that you're giving up your right to cross-examine all the witnesses the state might call against you, is because that's what you want to do?
Yes, sir.
All right. The next 2 questions the U.S. Supreme Court makes me ask of every kid who sits in that chair. Are you an American citizen?
Yes, sir.
Where were you born?
Texas.
All right. Do you remember what city in Texas?
Irving.
Irving? Okay. I know it seems kind of silly. If Mr. Adler were sitting in that chair, I'd have to ask him those questions too.
Yes, sir.
If Judge Kim were sitting in that chair, I'd have to ask him those questions too. Now, okay. Ms. Smith,
Yes, Your Honor.
are we proceeding on the entirety of the state's petition?
Yes, Your Honor.
Is that your understanding, Mr. Adler?
Yes.
Okay. All right, Ms. Gonzalez, the state has alleged that on or about April 21st of this year, here in Tarrant County, Texas, you intentionally gave a false name, namely Jessica Martinez, to endear a person that you knew to be a peace officer who would have lawfully arrested or detained you. We commonly call that giving a false identification to a peace officer, and it's a misdemeanor. You understand the charge?
Yes, sir.
All right. Is that allegation true or not true?
True.
Are you telling me it's true because it really happened?
Yes, sir.
Did anybody force you to come in here and say that?
No, sir.
Are you telling me the only reason you're pleading true is because that's what you want to do?
Yes, sir.
All right. Now, if there's an agreement between you and your attorney and the prosecutor in this case regarding what should happen here, and if I follow that agreement, you give up one more very important right. We call that the right of appeal. And that's where a different court located in downtown Fort Worth would look at what we do here today to make sure that everything was done correctly. But if there's an agreement between you and the prosecutor regarding what should happen here, if I follow it, there won't be any appeal. Do you understand that?
Yes, sir.
And knowing that that's the possibility, there won't be any appeal. That's a very important right. You still wish to go forward today.
Yes, sir.
All right. Mr. Adler, do you have any reason to believe that Ms. Gonzalez lacks a factual as well as rational understanding of these proceedings or the charges against her?
Not at all, Your Honor.
I agree. Just based on my brief interaction with Ms. Gonzalez this morning, it's very apparent she understands what she's doing. She's a very mature 16-year-old. And so the court will make that finding of competence. Does either side believe there are any additional admonishments that need to be given at this time?
No, Your Honor.
No, Your Honor.
Anything else from either side regarding adjudication?
None from the state.
None from a respondent, Your Honor.
All right. Ms. Gonzalez, based on our interaction this morning, I will find that you are competent in your plea true. I will find the allegation in the state's paragraph of its petition to be true and find that you did engage in delinquent conduct that would constitute a misdemeanor if engaged in by an adult. And that will be the finding of the court. We are back on the record in cause number 323-11358-0-20 in the matter of Emma Gonzalez. We are here for a disposition hearing. Are both sides ready to proceed?
State's ready.
Ready, Your Honor.
Smith, you may proceed.
State would offer petitioner's exhibit number 1, the social history.
All right, Mr. Adler, have you had a chance to review the social history in advance? Are you aware of any additions, corrections, or deletions that need to be made there too? Do you have any objection? State's petitioner's exhibit 1 will be received and admitted. State.
State would call Felicia Guerrero.
All right, Ms. Guerrero, please raise your right hand. You solemnly swear or affirm that the testimony you give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God. All right, Ms. Guerrero, you may remain standing where you are. Ms. Smith, you may proceed.
Ms. Guerrero, how are you employed? I'm sorry, Your Honor, I cannot hear her.
Court officer for the Juvenile Department in Tarrant County.
Okay, and are
Oh.
you the,
Hold on.
All right, you may proceed.
okay,
I'm a court officer with the Juvenile Department in Tarrant County.
okay, and are you the person who put together petitioner's exhibit number 1, the social history?
Okay, hold on. All right.
Judge, I have a suggestion.
Do I need to go to the other
Or
courtroom, Judge?
can detention just put Emma in the jury box and let Felicia sit right there?
Ernie, can you take that off mute? And it's the computer that's on mute, not Zoom.
It's not on mute, Judge.
It's not on mute, but the computer itself
Oh.
is muted. The sound is muted on there. You got it? Okay. All right, Ms. Smith, let's see if this will work.
Okay. All right, I'll try to make this brief. Ms. Guerrero, are you the person who put together petitioner's exhibit number 1, the social history?
Yes.
Okay. Has Emma been in trouble with this or been referred to this department prior to this?
No, she has not.
Okay. Although she's not been referred to this department before, do you think that it would be in her best interest that she be placed on probation?
Yes.
Why do you say that?
She is a frequent runaway individual. She is at a high risk of possibly being trafficked or a victim of trafficking, which it hasn't been confirmed.
Okay. Who does she currently live with?
Her mother.
Okay. And has your mother expressed to you that she would prefer for her to be back in her home and back in the community?
Yes.
Okay. Does Emma have any substance abuse history?
Yes. Emma did admit to me of using substance.
Okay. Is she currently enrolled in school?
Yes, she is.
And how is she doing in school?
Well, she was, according to her mom, she was not working on her packets that were being given to her for her to work at from home.
Okay. What ultimately is your recommendation to the court in light of everything that you have found out about her and within the social history?
I believe that she does need to be placed on probation. She needs to enroll in counseling with the Lions for Children who I have spoken to, and they're willing to take her. And also she would be referred to Unbound Advocate, where she would be assigned an advocate to work with her. And I believe that she would benefit from the electronic monitor. And I also will ask the court to order her no association with the companion on the case, which is Haley. And the last name is Sherrod.
Okay. I'll pass the witness.
Mr. Adler,
No questions, Judge.
may this witness be kindly excused by both sides?
No objection.
Yes, Your Honor.
Who would the state call as its next witness?
The state would arrest, Your Honor.
Mr. Adler?
Judge, I'm going to sit here real quick.
That's fine.
Your Honor, just to expedite matters, I'm not going to call any witnesses, but I did speak to the dad, and I think the dad and the mom are in agreement with the services. They do want her to go home on the electronic monitor today. So I won't ask any questions of the parents like I normally do.
And the court will take judicial notice of the fact that the father is in the courtroom and was nodding his head in agreement with the professional statement of counsel. All right.
And on that, I rest, Your Honor.
All right. Summation, Ms. Smith.
Your Honor, I would just ask that you follow the plea agreement of 12 months probation, and that the respondent be ordered to participate in counseling through Alliance for Children and participate in services from Unbound. And wear electronic monitor as long as the court sees fit, and submit to any random UAs that her probation officer may ask of her. And as Ms. Guerrero added, that she have no contact with co-respondent Haley Sherrod.
All right, Mr. Adler.
Judge, on behalf of Emma and her parents, we're in agreement with everything Ms. Smith just relayed to the court.
All right. Rebuttal, Ms. Smith.
None.
All right. Ms. Guerrero, I will find that you are a child in need of rehabilitation. I will further find that granting you probation is in your best interest as well as the best interest of the community. We will follow the agreement of the parties. By doing so means you will have no right to appeal. Okay, I just want you to know, if you have any questions about your right to appeal, Mr. Adler can give you some further advice. But with respect to the conditions of your probation, it will be for 12 months. I will release you today on the electronic monitor. If you do well on that, then the court will consider allowing you to take that off. Okay, but you got to do real well on it. Okay. I'm going to have you complete a substance abuse evaluation and screening and any treatment if indicated as a result of that evaluation. I want you to attend school and finish school like you're supposed to. I want you to stay on grade. That's real important. Attend counseling at the Alliance for Children and the Unbound Advocates. You will have no association with Haley Sherrod. All right? Anything else from either side?
No, Your Honor.
No, Your Honor.
All right, that'll be the report. Thank you.
Thanks, Judge.
Thank you.
Ms. Gonzalez.
Can I move this back?
Your Honor, are you able to hear me?
Just a minute, Mr. Youngblood. All right. Yes, Mr. Youngblood.
So I've been emailing back.
Hold on. Sorry.
Okay, it's okay. This is sort of an informal request real quick.
What's up?
I've been emailing back and forth with Mark Richmond, and he is not willing to reduce my client's case, which is my request of him. Earlier, I talked to my, well, that's his job. So earlier I talked to my client on the phone, and he was unwilling to go with the first degree, but I've not talked to him to tell him that Mr. Richmond does not want to reduce it to a second degree. So if you have the patience for it, and you can put us in a, I think they call it a private room, I'll ask my client whether he wants to do that or not. Otherwise, we just have a detention hearing.
Not a problem. Let's see. And this is on Daniel Zavala, correct?
Yes, sir.
Ms. Rodriguez?
Yes.
Ms. Rodriguez, if you could have detention. Why is he not broadcasting? Oh, they put the screen down back in detention. If you could have them bring Mr. Zavala.
Yes, Your Honor.
And that way I'll set up a breakout room for you, Mr. Youngblood.
Thank you, Judge. Thank you, Mark.
Welcome.
You mean you don't want to give up that first degree felony?
Yeah.
What's wrong with disorderly conduct? A real nice class C.
I don't think we have jurisdiction over that.
Yes, we do.
He was there earlier because I talked to him.
Okay. I thought that was him. Do we know anything more about the shooting at the park last night with 600 people?
Holy cow. No, I didn't know that happened.
Oh yeah, it was all over the news this morning. 5 people got shot at a park somewhere in Fort Worth. There was a gathering of over 600 people.
Good Lord.
Yeah.
I suppose, Judge, that Governor Abbott's orders might have been violated. So was this a juvenile matter as well, or were the suspects adult?
I have no idea. All I've heard is that 5 people were shot. It was at a public park around 7 o'clock last night, and 600 people were crammed into the park like stupid.
That's pretty stupid.
So.
When I was a prosecutor, there was a gang shootout at a parking lot next to a park, and they found over 200 rounds on the ground afterwards. 2 people were hurt. One of them shot himself in the penis when he was pulling his gun out of his pants, and the other one shot himself in the knee when he was pulling his gun out of his pants, but no one else was hit. So maybe gangs have gotten marksmanship training since then, but amazing. 200 rounds, no one actually hit in anger. Lots of cars shot up.
Oh, there we go.
That's Daniel.
All right, Mr. Zavala, give me just a minute. I'm going to create a private internet chat room for you and your attorney to talk, okay?
Yes, sir.
All right, y'all should have something on the screen that says y'all can join the client counseling room. Uh-oh. And we've lost the kid. Instead of joining the client counseling room, he just exited Zoom. So, Ms. Rodriguez, I bet that detention will have to restart the Zoom meeting session. Here he comes.
The parent is coming in just 1 second, okay?
All right.
Okay.
All right. Mr. Zavala, let me try and get you into that room. Hold on.
Maybe.
There you go.
Your Honor,
Yes,
the mother was in the restroom. Her daughter went to get her, so she'll be here in just a second.
that's okay. Mr. Youngblood and Mr. Zavala need to talk privately first.
Okay.
So the attorney and the child are speaking in a private room.
Okay.
Once they get done talking, they'll come back. Everything you can see, there's the judge on the wall.
Okay.
Right below you is the prosecutor.
Okay.
And then to the right of you is Karina, which is the PO.
Yeah.
And so you should be good.
Thank you.
And remember that all good. It's not you. So whatever y'all say or talk about, you gotta just listen. So some people forget. So yeah.
unlocked. I thought I unlocked it earlier. Oh, maybe I relocked it when I thought it was
Okay,
unlocked.
I'm back. Mark, can you hear me?
Yes.
Okay, he does not want to agree to a first-degree felony, so I'm going to ask Judge Porter to just have a detention hearing. I don't know if that'll be now or later.
Okay.
All right. Mr. Zavala, my name is Judge Porter. This is a detention hearing to determine if you should remain in custody or be released to a parent or guardian. You have the right to have this hearing recorded. You also have the right to have this hearing in front of Judge Kim if you want either of those things. We can make either of those things happen because Judge Kim will be doing detention hearings at 10:30. But if you want to do it in front of me, we can go ahead and go right now.
I'll do it in front of you, sir.
All right. All right, Mr. Zavala, pull your chair a little closer to the computer and talk up a little bit more for me when you're talking. All right. So, Ms. Rodriguez, what brings Mr. Zavala to court today?
He was referred in custody on April the 9th for aggravated robbery. The victim was selling ice cream and he was being followed by 2 Hispanic juveniles on a bicycle. One of the suspects told him to give him his money. He said the suspect pulled up his shirt and removed a handgun from the pant waistline. He reported after he gave the suspect the money, he was struck on the head with the butt of the handgun by the suspect, causing him to feel lightheaded. Benito Gutierrez and Daniel Zavala were identified as the subjects that committed the robbery by a witness that saw it occur. Both individuals were brought before a judge for questioning. Benito confessed being part of the robbery and taking the gun from a friend and giving it to Daniel. Daniel confessed to his part of the robbery by having the gun and hitting the victim with the gun in the head and taking the money from the victim.
All right, Ms. Rodriguez, repeat that last sentence for me real quick.
Daniel confessed to his part of the robbery by having the gun and hitting the victim with the gun in the head and taking the money from the victim. And
Okay.
the victim was recovered. And he has no prior history and he is on 1-0.
All right. What says the state?
Judge, based on the conduct, including the fact that he was the one carrying the BB gun and pistol whipping the victim in this case, we'd ask for continued detention.
Mr. Youngblood.
Well, I'd argue with the term pistol whipping because it implies multiple strikes, but I don't know if it's clear, and I want to make it clear because of my duty to honesty to the tribunal, that this particular BB gun has the general weight and heft of a real gun, according to the detectives. And so I would certainly not argue ever that being hit in the head with it is not painful.
And for purposes of the record, the court overrule your objection to counsel's argument as a reasonable deduction from the evidence. All right.
All right. He's on level 1-0, Your Honor. He's never been on probation, or as far as I know, even brought to the detention center for an investigation before. He has, in fact, been cooperative with the detectives and expressed actual remorse for his part in this. And so I see that his mother is here, and assuming that she is willing to take him home and understanding that the judge would probably have a number of severe restrictions on his freedom, I request that he be permitted to leave, especially given the pandemic that we're having, and apparently he does not have any symptoms of it.
Do you wish to ask the mom any questions?
Yes, sir, if that's possible.
All right. She's here. Do you see her on the screen?
I do.
All right.
Ma'am, can you say your name? Real loud.
Perla Barone.
Little louder.
Perla Barone.
Okay. Are you my client's mother?
Yes, sir.
Does he live with you?
Yes, I just moved back to Texas, or to Tarrant.
And where do you live? I don't need an address, but what city are you in?
Fort Worth.
Okay. Is your home set up to have him live with you?
Yes.
Does anyone else live there?
My mom.
How old is she?
52.
Is she in a position to assist you in supervising Daniel if he's allowed to come home?
Yes.
Does he obey you and your mom when you tell him to do things or not do things?
Yes, he obeys me.
Okay. Are you willing to have him come home and be with you, or do you feel he should stay at the detention center or be released if somewhere not to you?
No, released to me.
Okay. Do you understand what it is that he's accused of doing?
Yes,
Do you understand that's a very serious matter if it's true?
yes,
Do you understand the judge may require that he be on a monitor, which means he's not allowed to leave the house except to go to places like church and the doctor's office and other necessary outings from the house, not to be going to play basketball in the park or visit his friends or things like that?
yes,
Would you assist the court and report to the court if he violates it, even if the monitor doesn't go off?
yes,
Do you understand it would be very likely in this kind of situation that the judge would require that he have absolutely no contact with the other kids who are involved in this case? And that even means by telephone or email or Skype or whatever way they have to communicate.
yes,
Are you willing to cooperate with that?
yeah, yes,
It might mean that you would be told that he cannot have access to a video device or a phone without your being there at the time to make sure he's not talking to these other kids. Does that make sense?
yes, it does.
Okay. Did everything I say make sense? I know it's a little awkward doing this on a TV screen. Do you have any questions?
No, I don't.
Thank you, Your Honor. That's all I have.
Mr. Richmond.
Clarify, your mother is that Bainey Soto?
Yes,
And that's Daniel's current legal guardian?
yes,
And that's who had custody of Daniel prior to this incident?
yes.
All right, no further questions.
Where did he get the BB gun? Mom, where did he get the BB gun?
Well, from what I've been told, he got it from a friend. They gave it to Benito and Benito gave it to him.
And Your Honor, the gun has been recovered.
Mr. Richmond, did the police have the gun?
I believe so.
Okay.
Actually, let me check.
Mom, do you have any other weapons of any kind in your house?
No, sir.
What's going to stop him from getting another weapon from another friend?
He's just, I'm not sure, sir.
You understand why I'm scared?
Yes, I do.
Ms. Rodriguez, what time of day did this allegedly occur? Is this in the afternoon? And what was the date of the offense again?
It was April 9th around 6:30 in the evening.
So, Mr. Youngblood, this is why we were all on lockdown.
I'm sorry.
April 9th. This allegedly occurred on April 9th while we were all supposed to be on lockdown.
I thought you said why. You said while. I understand. Okay.
Yeah.
Yes, sir. That's correct.
Daniel, do you understand why that also concerns me? You're not even supposed to be out of the house.
Yes, sir.
And so obviously you're not amenable to your parents' supervision, are you? If you're out running around where the rest of us are supposed to be in quarantine, supposed to be in our houses, not going out, not doing anything. And if your mom is correct that a friend gave you this very realistic looking BB gun and you use it to steal money from an ice cream man, you understand why this is more serious than what you probably think it is.
Yes, sir.
Judge, to follow up on your question, to confirm it was seized by law enforcement.
Okay. I'm waiting on the court coordinator to bring me some information before I make a final decision. Thank you. No, not right now. Okay. Mr. Zavala, you have been either level 1.0 or level 1 acceptable since April 13. That's almost a complete month. So, despite your stupidity on April 9th, you've proven to me that you can follow the rules. I'm going to be perfectly honest with you. If we did not have this coronavirus thing going on, I wouldn't let you go. I don't like kids who rob ice cream man with guns. That's scary. However, I think for right now, your health is going to be, you're going to be better off being at home. So I am going to order that you be released on the EM, electronic monitor today. You need to know that you are not allowed to leave your house for any reason except for church or school. And both of those things have to be pre-approved by both your mother and Ms. Rodriguez. If either one of them says no, then you have to stay home, okay?
Yes, sir.
And it's not one of those things that you call up Ms. Rodriguez 5 minutes before you want to go to church and say, hey, can I go to church today? You have to plan in advance. That means if you want to go to church on Sunday or Saturday, you have to call Ms. Rodriguez on Thursday or Friday at her office to see if she will give you permission to go, okay?
Yes, sir.
You have to plan ahead. And if you don't plan ahead, then you don't get to go. Also, if your mom tells you that you can't go, you get to stay home, okay? But church and school are the only exceptions that I will allow the probation officer to approve. And if Ms. Rodriguez decides in her fair judgment that you have not yet earned the right to leave your house to go to church, then you stay home. If your mother decides that you have not yet earned the right to go to church, then you stay home. You got that?
Yes, sir.
No exceptions. If you leave the house, if you tamper with your electronic monitor in any shape, form, or fashion, I will find out, and I will, not I might, I will issue an arrest warrant for you, and you'll be back in Kimbo. Do you understand that?
Yes, sir.
Mom, he is to stay in Tarrant County. He may not go back to New Orleans. He might not travel outside the county for any reason unless it's a health emergency. Do you understand that?
Yes, sir.
You also understand that you are responsible for making sure that he gets to all of his court appointments.
Yes, sir.
If he fails to come to court, two bad things happen. First, I will issue a warrant for his arrest. The second thing is, because this case is so scary and so serious, there's a very strong possibility that if he doesn't come to court when he's supposed to, that I will issue a order that will result in you being taken to the Tarrant County Jail.
Okay.
Now, knowing that you could go to the Tarrant County Jail if he doesn't come to court, are you still willing to take a chance on him?
Yes.
Are you sure? Because you hesitated there.
I'm sure.
Okay. Daniel, I'm not kidding about this. You mess up on the electronic monitor and you're back in Kimbo. That's all. That's it. You understand?
Yes, sir.
Anything else from either side?
Yes, sir. The other people who are alleged to have been involved in this, there's 3 of them. They're listed in the report.
Well, he's on lockdown. He's not going to have any contact with any of them. And I'm going to trust that mom will regulate his access to the internet. Daniel, you are not to be using a cell phone or a computer unless it is for school and a parent is watching you.
Yes, sir.
Okay? So no online gaming, no talking to your friends. The only reason you get to talk to your friends is if it's concerning schoolwork, and your mom or your grandmother has to be sitting right there with you, watching you while you're talking to them. You're on lockdown. You're essentially on house arrest, and you don't get visits or talks to anybody. You got that?
Yes, sir.
All right. Mr. Richmond, anything else creative you can come up with?
I was going to say no contact with the co-defendant or the ice cream man, but that's all I got.
All right. All right. That's the order of the court. Thank y'all.
Thank you, Your Honor. Thank you, Mark. Thank you, Karina.
Thanks, Edmund.
Okay. Larry, ready to go on that? Yeah. Okay. All right. Mr. Beaver, I appreciate your continued patience.
Thank you, Your Honor.
Mr. Beaver's client, I believe Mr. Marshall. Correct. Is that Zavala? Okay. I was just getting ready to write that order for you. Okay. I wrote the release conditions on the docket sheet. Is that going to be good enough? Or you need me to do it on this too? Here we go. All right. Awesome. Thank you. Yes. Oh, the written part, that is all, it all needs to change. The what?
I know you were trying to create a framework for it, but I just wanted to.
Oh, yeah. Yeah. Okay. There we go. Anytime.
I'm sorry, you said Marshall, what you're doing?
Yes. And Judge Kim is doing detention hearings.
Separately?
Yes.
We have two Zoom things going?
Yes. I'm going to try and finish Marshall up though, so I'll be out of his way completely. Yes. If you'll hurry and get him in front of the computer, we can get him done. Okay. Mr. Beaver, I believe they're trying to get your client in front of the computer right now.
Thank you, Your Honor.
Gutierrez is not going, and Moreno is also rescheduled. Yeah. And I don't like these hybrid hearings because the echo and trying to control the computers is too hard.
Oh, when they're here?
Yes.
Yes.
Oh.
That's ours. That's
Okay. Then there's a computer in there. Yes. Let's say.
Or the jury room. Either one is fine.
Oh, that's so much better.
That room is meant for. Yeah, there's no way to do both.
Here we go. I'm sending you this now. I'm just going to send you the MS Word file.
All right, thank you.
Done. I just did set it up that way just because trifold would be easy. We'll need to reformat it then if we're gonna. And there's probably more different stuff.
Order this and point to FAQ.
Okay. Okay. Mr. Beaver, have you had a chance to review the social history in the next case?
For Mr. Marshall, yes.
Okay. I also, looks like the state has submitted a second petitioner's exhibit. Were you aware of that?
On what date?
Ms. Smith, I don't remember when you brought it. Did you bring it to me today?
Yes.
Victim court report.
Okay, the victim impact report, I think that I already had an opportunity to review in the discovery.
Okay.
Open.
We only have 30 minutes to get this next one completed. So I'm going to be talking really fast once they get the kid in front, because we do have to be out of Judge Kim's way by 10:30 so we can get detention hearings rolling okay.
That works. Your Honor, if you want, I can skip calling the probation officer if you just want to review the social history at that time. Is that okay?
That's fine with me.
Okay.
I'm not going to tell you how to run your case.
Sure.
Are you Miss Coles?
Yes.
Okay. Just trying to make sure I understand who everybody is before we get started. We're just waiting on detention to bring Mr. Marshall up. We'll get going. Oral argument. Because it's an interesting case today. Native American out of Oklahoma got prosecuted in the second court for state crime. He was on regulation. He's arguing that Oklahoma can prosecute American under tribal law. But when yeah. Dollars to donuts. I personally know the prosecutor. I have not asked her, but I personally know the prosecutor in a trial. She's actually a USA assistant USA in Tulsa, that she prosecutes tribal stuff. She handles 90% of the tribal docket. It's all going to come down to how the Supreme Court interprets the treaty creating Oklahoma as a state. It's a fascinating case. It's as far as big picture case, it's a really small thing within the great panoply, but it's an interesting issue of law, and it will affect her directly because that has to do with most of her caseload.
Yeah, I got here, I don't know, 7:15.
Oh, early, way early.
I was talking to a friend of mine, Dawn, downtown.
Yeah, we're being broadcast. But we're still, I can't cut it off, so. Who's on bike patrol? Sam? Oh. Okay. Mr. Beaver, Ms. Smith, unfortunately, at this point, we've only got 24 minutes left. There's no way we can get this hearing done in 24 minutes because I have to go over the stipulation of evidence line by line with the respondent, and that itself takes about 10 minutes. So we can either reschedule this for a different date, or y'all can come back at 1 o'clock and I'll be back ready to go at 1 o'clock.
Your Honor, I believe that I'm available at 1 o'clock. I hope that Ms. Coles is also available.
Right, and she's the third person that we also need to make sure that we are considerate of her time.
I can be back at 1.
Ms. Coles, you can come back at 1 o'clock? That's not going to create a hardship for you, is it?
No.
Okay.
That's fine with me, Your Honor.
All right. I'm sorry, y'all, but I appreciate your understanding. So we will reconvene at 1 o'clock. If everyone will make sure that you're ready to go, keep this link to the Zoom meeting because we will use the same Zoom meeting ID at 1 o'clock.
Thank you.
Okay.
All right. Thank y'all. I appreciate it.
Thank you.
Thank you, Ms. Coles.
Thanks much. See you at 1.